Hello, and welcome to Information Exchange Without Borders. My name is John Roberti, and I'm a partner in the Allen & Overy law firm. I'm a member of Allen & Overy's competition practice, where we have 25 partners and more than 100 lawyers practicing competition law across the globe. Today, we'll be talking about competition risks associated with information exchange. Let's begin our program by talking about the basic framework for how we think about information exchange and competition risk, and I'll start with the United States. In the US, we think about competition risks of information exchange in the context of anti-competitive agreements. Now, there are certain types of agreements that are almost always going to be found to be illegal. And these are agreements to fix prices or divide markets or to allocate customers to rig bids or to reduce output. When you have one of these types of agreements, you don't need to have any more evidence in order to show that the agreement was in fact a violation. Information exchange is not by itself a per se illegal agreement. However, if you have information exchange, it can be used as evidence to demonstrate that an agreement was reached on one of these per se illegal categories, such as price fixing. So what types of information exchange can be compelling evidence of an agreement? Well, the worst kinds of exchanges have some common elements. First, the exchange typically involves competitors who should be competing and not collaborating with each other. Second, these worst exchanges also involve competitively sensitive information, such as pricing information or plans for customers or marketing strategies. Third, the most dangerous exchanges are also generally devoid of any business justification. And the lack of this justification, coupled with the sensitive nature of the exchange, creates a compelling story for a regulator that an illegal agreement was reached. Finally, in our experience, this most dangerous type of information exchange is often done with a guilty conscience. There are clandestine meetings or emails from personal accounts or cell phone calls, things that are made to try to hide these exchanges. So our advice about these most dangerous types of information exchanges is pretty simple. Don't do it. The best preventative steps are the steps that probably companies are already taking to avoid cartel issues. That's training, monitoring, reinforcement of policies. Now, there are lots of other information exchanges that go on regularly and that don't fall into this dangerous category, but yet may raise some risk. If the information exchange doesn't involve competitively sensitive information, for example, then it's very unlikely to raise competitive concerns. Likewise, if the exchange doesn't involve competitors, then the risks also will diminish. If the information exchange is competitively sensitive and the exchanging parties do compete, but there is a business justification for exchanging the data, the mode of analysis changes. Under those circumstances, courts and regulators assess the conduct by applying what we call the rule of reason. The rule of reason requires a regulator or a court to weigh the pro-competitive benefits against any anti-competitive effects. Now, there are lots of good reasons to do information exchanges, including to facilitate safety or security or innovation. So, if there's a strong basis for exchanging information and if the scope of the exchange is no broader than necessary to achieve the objective, then for the most part, the practice is going to be upheld. The key takeaway from this guidance is that most information exchanges will not raise concerns so long as, one, there is a reasonable business reason for making the exchange, and two, the exchange is managed in a way so that the exchanges provide no more sensitive information than necessary. Some of the techniques that can be applied to limit exposure and manage the exchange include: one, masking and aggregating data; two, limiting information to past information; and three, sharing raw data through a third party that then aggregates it or masks it and then shares it. A recent FTC blog confirms this approach suggesting that companies should ask themselves two questions before engaging in information exchange. First, what's the purpose and likely effect of the information exchange? And second, are there adequate safeguards to avoid even the appearance of chilling of competition? So with this in mind, let's look at some of the recent information exchange cases. I'll start with a recent one. In 2014, the US FTC brought a complaint alleging that the CEOs of two companies engaged in surgical hair transplantation violated the FTC Act by exchanging company-specific information about future product offerings, price floors, discountings, and other competitively sensitive information. The FTC concluded that this exchange could facilitate coordination and serve no legitimate business purpose. Another case involving information exchange was brought against three major U.S. suppliers of ductile iron fittings. The information exchange there basically was done in two ways. First, one of the companies provided a public letter announcing all of its price increases, and the FTC said there was no reason to provide that letter other than to signal competitors. Second, the companies exchanged recent pricing information through a trade association. The information was generally less than 2 months old, and the FTC said that this exchange allowed the companies to monitor each other and make sure none of them were cheating on the agreement. Ultimately, after a trial and appeal, the FTC found that there wasn't sufficient evidence to go forward, but the complaint itself gives good guidance as to the type of behavior that companies should avoid. There's another category of information exchange cases that should be noted, and these are the so-called invitation to collude cases. In invitation to collude cases, one company approaches a competitor and makes an offer essentially to reach one of the agreements on price or one of the forbidden terms. Even if the second company doesn't accept, the approach itself has been found to be a violation of the FTC Act. We've talked about some of the cases where the FTC has found a violation. Let's talk about some of the circumstances where the FTC and the DOJ have said information exchange is going to be okay. For example, the FTC and DOJ issued an antitrust policy statement involving sharing of cybersecurity information and concluded that the sharing of this type of information is unlikely to raise antitrust concerns. The FTC staff also recently advised the Money Services Roundtable that it would not challenge a proposed information exchange among money transmitters, which were designed to assist in complying with money laundering laws. The companies were going to keep a database identifying persons whose relationships were terminated due to a failure to comply with money laundering laws or money transmitter policies. And the FTC concluded that this type of exchange is unlikely to raise antitrust concerns, but has benefits in helping to comply with the money laundering laws. I think the approach to information exchange in the United States is well summed up by a recent blog post at the FTC, which said, quote, "Competitors can exchange information when the purpose and likely effect of the exchange is to make participants more effective competitors. To that end, let reason be your guide." Let's see if other regions view information exchange differently.
Hello and welcome to the EU and Information Exchange. My name's Vanessa Turner and I'm one of John Roberti's partners in the EU. I'm based in Allen Overy's Brussels office and I'm a partner in the competition practice. So let's look at the EU perspective on information exchange. In the EU, the competition law risks associated with information exchange are pretty similar to the US, but actually tend to be a bit greater as Europe generally takes a stricter approach to information exchange between competitors. Whilst EU law recognises in its enforcement that information exchange can be pro-competitive, exchanges of information between competitors can also be viewed, in the worst case, as a cartel. As in the US, the starting point is generally that competitors should be competing and not cooperating. Secondly, the worst exchanges involve the most competitively sensitive or strategic information, such as future pricing information or plans for customers or marketing strategies. And third, the most dangerous exchanges are also generally without any valid business justification. That, coupled with the sensitive nature of the information, will be likely to lead to illegality. And as John said, in our experience, this kind of information exchange is often done with a guilty conscience, clandestine meetings, or communications via non-business electronic communications or phone lines. Our advice on that type of information exchange is pretty straightforward: don't do it. The best preventative steps against that kind of exchange are obviously training, monitoring, and reinforcement. However, this is certainly not the only type of information exchange that can fall foul of the law in the EU. In the EU, unlike the US, no agreement is required for an exchange of information to be illegal. The unilateral provision of information by one competitor to another can also be illegal. At this point, I think it's useful if I set out some of the principles under EU law. I should also point out that the member states of the EU apply very similar principles, but if anything, their enforcement record is actually more strict under national competition rules than in the EU. So looking at EU law, the relevant article for the EU is Article 101 of the Treaty on the Functioning of the European Union. 101 Paragraph 1 prohibits agreements and so-called concerted practices whose object or effect is anti-competitive unless, under Article 101 Paragraph 3, the pro-competitive effects of such agreements outweigh the restriction of competition. So looking at these principles more specifically in relation to information exchange, obviously the concept of an agreement is probably going to be fairly clear, but concerted practice is a different concept and refers to a form of coordination between companies by which practical cooperation between them is knowingly substituted for the risks of competition. The prohibition on anti-competitive concerted practices precludes any direct or indirect contact between competitors, the object or effect of which is to influence the conduct on the market of a competitor or to disclose to such competitor a company's own proposed course of conduct, thereby facilitating a collusive outcome on the market. In a situation where only one undertaking discloses strategic information to its competitors who accepts it, it can also constitute a concerted practice. Should such a disclosure occur, for example, through contacts via emails or phone calls or meetings, it's irrelevant whether only one undertaking unilaterally informs its competitors of its intended market behaviour, or whether all participating undertakings inform each other of their respective deliberations or intentions. When one undertaking alone or company alone reveals its competitors, to its competitors its strategic information on prices, for example, that reduces strategic uncertainty as to the future operation of the market for all the competitors involved and can increase the risk of collusive behaviour. So putting that in slightly more concrete context, the mere attendance at a meeting where a company discloses its pricing plans to its competitors is likely to be caught by Article 101, even in the absence of an explicit agreement to raise prices. So when a company receives strategic information from a competitor in a meeting or electronically, it will be presumed to have accepted the information and adapted its market conduct accordingly, unless it responds with a clear statement that it does not wish to receive such data. This means a one-way communication is sufficient for there to be an infringement under European competition law, and the European Commission, which enforces the law, does not have to show that the recipient of the information will actually take it into account when setting its own commercial policy, as this can be presumed. And while this presumption is rebuttable, so far there have been no successful rebuttals. Turning to another area, when a company makes a unilateral announcement that's also genuinely public, for example, it announces a policy in a newspaper, this normally doesn't constitute a concerted practice which would be illegal within the meaning of Article 101. However, depending on the facts, the possibility of finding a concerted practice can't be excluded. For example, if the announcement is followed by announcements by other competitors who are strategically responding to each other in order to try and reach a kind of common strategy on the market or an understanding about the terms that they're going to be acting on in the market. So, having explained the concept of concerted practice, I want to now briefly look at the concepts of restrictions of competition by object and by effect, as this is quite important under EU law as well. The exchange of market information may lead to restrictive effects if the characteristics of the market are of a particular type and depending on the type of information that's exchanged. The likely effects of an information exchange on competition have to be analysed on a case-by-case basis, however. As regards by-object restrictions, according to the European Commission's Guidelines on Horizontal Agreements, which actually have a significant section on how the European Commission, the enforcer of EU law, views information exchange, and I'd refer you to those, according to them, any information exchange with the objective of restricting competition on the market will be considered a restriction of competition by object. And in assessing such information exchange, the Commission will pay particular attention to the legal and economic context in which the information exchange takes place. So exchanges between competitors of individualised data in relation to future prices or quantities are going to be considered, according to the Commission, as a restriction of competition by object. And if those exchanges take place in private between competitors, it's very likely that those exchanges would be considered and fined as cartels. So that's the theory. What have we seen in recent cases? I'm going to look at EU level and at member state level. There have been two notable cases at the EU in recent years which illustrate how information exchange is assessed under EU law. That's leaving aside the classic cartel cases. First of all, in the Court of Justice's T-Mobile judgment, the anti-competitive conduct at issue resulted from one single meeting during which the future intentions of telecoms operators affecting dealers, so not consumers, were disclosed between competitors. The court said that passive receipt of unsolicited strategic information at just one meeting is a concerted practice and amounts to a restriction by object, so that there's no need for the effects of such practice to be analysed. The court also went on to say that a causal connection between the information exchange and the future market conduct will be presumed unless the contrary is proved by the recipient firm. So it's clear from this that it's not the number of exchanges involved or whether the exchange is reciprocal that mattered. The key question is whether the information exchanged is capable of influencing the party's conduct on the market. Another interesting case is the bananas cartel. And in that case, the Commission considered that bilateral discussions twice a week between banana suppliers on price-setting factors served at least as market signals on the development of banana prices, and therefore amounted to a concerted practice having an anti-competitive object. The parties argued a number of things, but in particular that the information they disclosed was public information only. But the Court on Appeal held that even if the information could be obtained from other sources, the parties' point of view on certain information and its impact on the development of the market was not public available information, and the timing of the exchanges between the competitors shortly before prices were set and the frequency of those communications meant that, in the views of the court, the parties were disclosing their course of action, and hence this was viewed as a problematic area of the law. Another area that the Commission is currently looking at is price signalling, but the cases on those are still pending, so I will park that there for the moment and move on to the cases that have taken place at the member state level. Now, as I mentioned earlier, the member states have been quite active in this area, but I'm only going to pick two examples to illustrate the cases that have taken place under the enforcement of the national competition authorities. Looking firstly at the UK, the Competition Authority in the UK objected to some price announcements in the context of an industry investigation in the cement industry. This case didn't actually involve any direct communication between competitors, but information about competitors' future pricing intentions, which was exchanged through the sending of price lists to customers. And this led to leakage, as most of the customers were also competitors in the sector. So the Competition Authority concluded that because of this market structure where customers and competitors were often one and the same, this was susceptible to coordination, and the use of price announcement letters was used as a signal to increase, to indicate price increases to competitors and thus facilitate price parallelism and also to soften customer resistance to price increases. So, as a consequence, the authority required generic price announcements by competitors to be replaced by individualised communications with customers only. This case was very fact-specific, but it does indicate a certain sensitivity in Europe, which is mirrored by other authorities in relation to price announcements, particularly when they're made with lengthy advance notice. I now want to turn to a case in the Netherlands, which was another interesting case in terms of public statements. The Dutch Competition Authority looked at some public statements in the telecoms sector and took measures against two types of public statement that it believed could potentially lead to anti-competitive collusion. Although no infringement was found in this case, the Dutch Competition Authority required commitments from the telecoms operators, MNOs, in order to avoid the risk of future collusion or collusive behaviour in the industry. So what were the statements? The first one was made by one operator, KPN, during a panel discussion at a Dutch telecoms conference, and it signalled that KPN planned to recommence charging connection fees, to which another competitor, Vodafone, responded that it hoped that KPN would follow through with this plan. Later, internal Vodafone documents indicated that it also planned to resume charging connection fees if KPN did. Then, sometime later, several other MNOs followed suit. The second statement that was made by KPN revealed in generic and non-specific terms the company's intention or potential intention to increase its prices. Internal documents of other competitors showed that that statement was picked up, and that the others, or at least one of the others, concluded that they would also implement a price increase. So the Competition Authority considered that these statements were problematic in light of the specific characteristics of the telecoms market being a highly concentrated market and so on, and that that would lead to a facilitation of tacit collusion. So then, in order to address the potential competition concerns, the MNOs committed not to issue any public statements about future prices or other commercial conditions before the internal decision-making processes had been finalised. And there was actually a carve-out for analyst statements. But that shows you that there is quite a lot of development in this area in Europe. So what does this all mean in practice for companies? I think we can look at three particular rules. Firstly, if the information exchange does not involve competitively sensitive information, it's unlikely to raise concerns. Secondly, if the information exchange is sensitive and the exchanging parties compete, but there is a clear, legitimate business justification for exchanging the data, and this is done in an appropriate way, for example, only historical aggregated data, then the courts and the regulators can assess the conduct, the information exchange under Article 1013 that I mentioned, weighing up the pro-competitive benefits of the practice against any anti-competitive effects. However, in all other circumstances, exchange of information between competitors will be risky and in the worst case considered a cartel. The key questions a company should ask in the EU, in fact as in the US, are: what type of information is being exchanged? What is the purpose and likely effect? Why would one competitor be telling another about its strategy? And lastly, if the exchange is legitimate, are there adequate safeguards to avoid even like an inadvertent chilling of competition?
Hi, I'm Peter McDonald from the Allen Overy Sydney office. I'll talk about the risks associated with information exchange in an Australian context. The core risks that arise are the absolute prohibitions against cartel conduct between competitors, or understandings that substantially lessen competition, or unilateral attempts to reach this kind of arrangement. As in the US, we are generally concerned about arrangements or understandings, and that involves communications and a meeting of minds about future actions. Of course, that is the worst case scenario, and there are many types of legitimate business interactions between competitors that involve information exchange. In a practical sense, risks are generally assessed by reference to, firstly, the type of information exchanged, with forward-looking, sensitive and strategic information raising the greatest concerns, and also with highly detailed and specific information being of greater concern than more general or aggregated data. Secondly, we look to the reason for the exchange and whether or not there is a legitimate business explanation. Thirdly, we look to the circumstances surrounding the exchange, including any related communications, the commercial context, and the actions of the parties after the information has been exchanged. Where there is no direct evidence of a cartel arrangement, but there is evidence of sensitive information exchange, the competition regulator will generally seek to piece together circumstantial evidence to prove up the existence of an anti-competitive understanding. So the first and the biggest risk is of a costly, distracting and extremely stressful regulatory investigation, probably in a criminal context. The next risk is of prosecution in the federal court. Cases involving pure information exchange and only circumstantial evidence of cartel conduct are very difficult, and the reality is the regulator's success has been mixed. This leads me to my final thematic point. Some notable failures in the court by the regulator to prove these type of cases have resulted in calls for law reform in Australia. This process is significant and ongoing. Firstly, special industry-specific laws were developed for the retail banking sector. The impact of those laws is that private exchanges of sensitive information are prohibited outright. The regulator, in fact, wants this sector-specific law expanded to all industries, but has found precious few friends in the business and legal communities. Secondly, the federal government announced a comprehensive review of Australian competition law. The interim report, which is now released, recommends that Australia should legislate to introduce a broad prohibition against concerted practices. That would bring Australia in line with the European position. In line with those policy initiatives, the regulator itself has shown a recent increased willingness to take on difficult cases and to test the boundaries of the law. For example, a very high-profile case that is currently before the federal court involves allegations that the major petrol retailers have acted anti-competitively in participating in a third-party managed retail petrol price monitoring system that provides granular and near real-time petrol pricing information.
Hello, my name is Shalpa Mies. I'm a counsel in Allen & Overy's China antitrust practice in Beijing. As you will have heard, the treatment of information exchanges under competition law is considered a grey area in many parts of the world, and China is no exception. Information exchanges, in fact, have not received a great deal of attention so far in China, compared to what has been the case in other jurisdictions. But there are at least two good reasons to keep a close eye on information exchanges in China. First, you need to consider the cultural context. Sharing business information is very common in China. Business relationships, just like other social relationships, are based on the concept of guangqi, that is, the multiple connections based on mutual interests and benefits which constitute a social norm in China. This is actually more than social interactions. It is considered important to build good relationships not only with customers, but also with suppliers as well as competitors. And this may, of course, knowingly or not, prompt exchanges of information that are commercially sensitive. There is therefore a delicate balance to strike between maintaining a strong network in line with Chinese culture and ensuring that exchanges do not infringe competition law. I should also note that trade associations play a very important role in China. They typically work closely with the government. They collect extensive data, they establish statistics, and they also maintain self-discipline within a specific industry. This again creates a forum in which inappropriate exchanges can easily take place. The second reason why information exchanges are important in China is because there are clear references to them in the definition of what constitutes a concerted practice. Now, before I get to that, however, let me take one step back and give a very brief overview of the Chinese competition law enforcement system. This will be useful to understand how information exchanges could be assessed in China. The law on competition is called the Anti-Monopoly Law, or AML. It entered into force in 2008, and there are 3 agencies in charge of enforcing the AML at a central level of government. The first one is MOFCOM, the Ministry of Commerce. This is the agency that is probably best known to an international audience. MOFCOM is in charge of enforcing the merger review provisions of the AML. The second one is the NDRC, or National Development Reform Commission. The NDRC is competent for infringements of the AML, which relate primarily to prices. And the NDRC is also competent for the enforcement of China's pricing law. And the third agency is the SAIC, or State Administration for Industry and Commerce. The SAIC is in charge of enforcing many laws, including the AML, with respect to anti-competitive non-price conduct. You should also note that both the NDRC and the SAIC have local agencies that can pursue cases under the AML. And in fact, a lot of enforcement actions take place at a local level. It is actually difficult to get a full picture of all the actions under the AML. Chinese competition authorities have no obligation to publish enforcement decisions. Most of the cases, in particular the ones that are conducted at the local level, most of these cases are not publicized at all. And when they are, it is often unclear on what basis the decision is based. It's therefore unclear whether the decisions were taken under the price law or the AML.
One of the questions we're frequently asked about information exchange is, what are some of the best practices for engaging in a benchmarking study? A benchmarking study is an exercise where companies compare themselves to other similarly situated companies to see how they're doing in certain metrics. And there are lots of good reasons to do them. They can promote safety or security or innovation. They can also be good guides as to where companies are in certain metrics that can lead to more efficient decisions on spending or prioritization or costs. Now, when doing a benchmarking study, there are a few general principles that have been enunciated by the U.S. regulators in guidelines that they've published. And these principles are the following. First, information related to price, output costs, or strategic planning is more likely to raise concerns than other information. Second, the exchange of information on current operating and future business plans is more likely to raise concerns than the sharing of historical information. Third, the sharing of individual company data is more troublesome than sharing aggregated data. And finally, limiting access to competitively sensitive information to specified individuals, or even better, to an independent third party, lessens antitrust concerns. Similarly, the U.S. Federal Trade Commission has released guidelines regarding benchmarking studies among healthcare practitioners. The guidelines, although they're related to the healthcare industries, are generally applied to all industries and state that a benchmarking program that has the following elements will fall within a safe harbor, meaning that the FTC is committed not to pursue enforcement if a company meets if a benchmarking study meets these criteria. First, the data collection must be independently managed. Second, the data exchange must be more than 3 months old. Third, there must be at least 5 participants in the study. Fourth, no individual firm's data can represent more than 25% of the data in any particular statistic or metric. And finally, the disseminated information must be sufficiently aggregated to prevent the identification of the prices charged or other specific cost information of any specific participant. Now, being outside the safe harbor doesn't mean that the benchmarking activity will be condemned. All it means is that we're back to our standard analysis and that it could be subject to investigation. The key question then will become whether the benchmarking study is reasonable.
First question, what are the best practices for participating in a benchmarking study? Now, EU law recognises that benchmarking studies can be legitimate, but they have to be done in the right way. And this should be considered on a case-by-case basis, but essentially the same principles as the ones that John outlined for the US would also be advisable in the EU. So information exchange related to price, output, costs or strategic planning is more likely to raise concerns. The exchange of information on current operating and future business plans is more likely to raise concerns than the sharing of historical information, and the sharing of individual company data is more troublesome than aggregated data. So those are the kind of basic principles, and benchmarking should follow the following principles, very similar again to the US. Data collection should be managed independently by a third party. The data exchange should be at least 12 months old, actually not like in the US 3 months old, but again this needs to be looked at on a case-by-case basis. There should be at least 5 participants in the benchmarking exercise, and the disseminated information should be sufficiently aggregated to prevent identification of the prices charged by any specific participant.
One of the questions we often get about information exchange has to do with the release of public information or making public statements. The U.S. regulators have recently brought up several cases around executives making public statements that the regulators have alleged were aimed at competitors and were an attempt at signaling or unlawful information exchange. So there are a few practical tips that we offer to executives to help them avoid these traps. First, executives need to know the danger zones. The riskiest public statements are those that discuss future prices and output levels. Second, executives must focus on their own companies. So executives shouldn't presume to talk for the market or for the industry. Third, executives should be only as specific as they need to be. If more information is provided than necessary, regulators may suspect that the public statements are merely a vehicle to communicate with competitors. Fourth, it's important to be definitive in explaining future actions. By announcing conditional or contingent plans, a regulator could argue that the announcement is a signal meant to determine if competitors will agree, sort of a trial balloon. Finally, it's important to avoid speculation. It's particularly unwise to speculate about competitors' behavior or to say, for example, we think this price increase will stick.
Now looking at the question, what are the best practices for the release of public information or public statements? Here, a key point is not to announce a pricing or commercial policy until it is definitive. In other words, do not announce conditional or contingent plans, as this could be risky. John mentioned a few practical tips for executives in the US. These are equally valid in the EU. The riskiest kind of public statement is going to be the type that involves a discussion of future prices or output levels. If you're going to make public statements, the following principles in particular would be useful to respect in the EU as in the US. It's generally best not to announce price increases or similar acts publicly first, but first to announce them to customers definitively and not conditionally, and also only insofar in advance as is actually necessary. If you're making an announcement, focus on your own company. Don't speak for the market or for the industry, and if you're going to explain any changes in policy, refer to your own company and not, again, to any kind of industry reflections. Thirdly, if you're going to make public statements, you shouldn't refer to how the competitors are likely to act, and only be as specific as you need to be, because the more information you provide, the more likely it is that regulators may suspect that the public statements are a vehicle to communicate with competitors rather than customers, and avoid speculation on what other people are likely to do in response to your statement.
There is one important case regarding price announcements decided by the NDRC that needs to be mentioned here, even though it was not decided on the basis of the AML, but instead on the basis of the pricing law. So what is this case? In March 2011, Unilever sent letters to supermarkets informing them of price increases on a number of consumer products. So far, so good. The problem is that a Unilever spokesperson also gave several interviews to the press and made inappropriate comments. In particular, that spokesperson said that the industry had entered into a series of price increases. That person also said that competitors monitor each other all the time, and consumers are pretty price sensitive, which means that the only thing that you can do is to make only slight adjustments at any one time and hope that competitors would follow. And finally, Unilever said that they did not exclude other rounds of price increases. Now, what followed these statements was two things. First, competitors did follow suit and increase prices. And second, there was some sense of panic on the market, with consumers rushing to stores and retail prices increased by sometimes up to 100. Now, Unilever was eventually fined for disseminating information that disturbed the market order. The fine was 2 million RMB, which is about 280,000 euro or $320,000. And again, the fine was imposed on the basis of the pricing law, not the AML. But the fact that the NDRC, in its public statement, made reference to coordination with competitors and tacit collusion is a clear sign that the kind of price announcement made by Unilever would also likely fall under the AML.
One of the best practices for guarding against inappropriate information exchange during a transaction. It is very common for competitors considering a potential merger or other commercial transaction to exchange competitively sensitive information to assess likely risks and benefits and to price the deal. This is completely legitimate, but the competition regulator will nonetheless expect there to be in place appropriate safeguards to manage the exchange. In the ordinary course, you would put in place the following safeguards. Firstly, information exchange and use should be limited to identified and legitimate purposes. Secondly, dissemination of the information should be limited to individuals who have a legitimate need to use the data. Thirdly, records of the information exchange should be maintained, and if the deal does not proceed, the information should be returned or destroyed. Fourthly, a staged process of disclosure and the possible use of restricted clean teams or even third parties, such as accountants, should be considered for the most sensitive details. There is, of course, a high degree of commercial common sense in each of these well-established arrangements. Of course, they also provide an interesting guide and a point of reference for exchanges that occur outside the deal context. So what issues arise in Australia relating to information exchange in a joint venture context? In the energy resources sector in particular, it is commonplace for companies to form multiple JVs with their counterparts to explore for, produce and bring to market their products. When competition occurs across joint ventures, the obvious question arises is how sensitive information is managed by participants with multiple overlapping interests. As always, the solutions will depend on the facts. In Australia, there is also a joint venture defence for cartel conduct. However, the defence is technical and generally limited to reasonably necessary intra-venture arrangements, not to exchanges across agreements or otherwise distinct entities. One reasonably formal way of managing such issues, and which has been endorsed by the competition regulator, is to introduce information barriers or commercial ring fencing across market-facing data, people and systems. There is often quite a significant cost associated with those arrangements, but they also do bring with them a reasonably high degree of certainty that there is no cartel risk.
A lot of our advice today has involved what to do to avoid exchanging information, but there are times when companies become the unwanted recipient of competitively sensitive information from a competitor. Under these circumstances, these unwanted advances must be dealt with. And when a company receives such an unwanted communication, we believe the following best practices should be followed. First, it's important to reject the communication. The recipient of the communication should make clear that he or she, 1, believes the communication is not appropriate, 2, will make decisions unilaterally, and 3, doesn't want to receive similar communications in the future. Second, it's important to document the rejection. Be sure that the rejection is memorialized somewhere in the files. Now, it can be memorialized if in an email if the rejection is done in writing. If the rejection is made orally, it's important to draft a memo and put it in the file so that it can be pointed to if there's ever a question. Third, it's important to write down the reasons for subsequent unilateral competitive actions. Any immediate competitively sensitive decisions should be documented so they can be demonstrated to be independent of the inappropriate communication. For example, if a price increase is taken, the reasons for the price increase, such as increased costs, should be documented. Finally, we always suggest that clients confirm that the inappropriate advance is not just the tip of the iceberg. Sometimes when an employee receives a solicitation from a competitor, it's truly unsolicited. Other times, however, there's risky behavior that may have led to the note. At a minimum, it's important to interview the recipient. Depending on what's found, further investigation may be warranted. Sometimes clients ask us, well, why can't we just ignore that? We think ignoring the unwanted advances could be dangerous because it creates the appearance of agreement with the advance or, at a minimum, acquiescence. Sometimes that can be enough to initiate an investigation, and the investigations can be distracting and expensive. So, what should every in-house lawyer know about information exchange? The most important takeaway about information exchange in the United States is that managed information exchange done for a legitimate purpose is often going to be acceptable. Companies shouldn't shy away from legitimate information exchange because of fear of competitive law risks, so long as the information exchange is managed. The real competition risks from information exchange are generally the same compliance risks that are front of mind for corporations, namely the risk of being caught in a cartel. If information exchange is properly managed, those risks can largely be avoided.
So what should every in-house lawyer know about information exchange from the EU perspective? I think the most important takeaway about information exchange in the EU is that it is perhaps one of the most difficult areas of competition law to stay on the right side of the line. Cartel conduct is easy to identify and should obviously always be avoided. Beyond that, however, it's shades of grey, and information exchanges need to be assessed on a case-by-case basis. It is very easy to stray into the danger zone, so it's worth checking with any discussion between competitors whether it's really a good idea and to look carefully at the purpose of such discussion. Just ask yourself, why would a company tell its competitors about its current or future prices, output, capacity plans, or customers? And the more closer you get to information exchange on competitively strategic information, the more concerned you need to be. Historic information, on the other hand, is likely to be less concerning. Particularly future information on prices, quantities, or customers is going to be potentially critical. Another thing to look out for is your information exchange sales-led or is it production-led? The latter is likely to be less critical than the former. Finally, carefully managed information exchanges done for legitimate purposes are, on the other hand, often going to be fine.
What should every in-house lawyer know about information exchange in Australia? Understanding and managing risks associated with competitor information exchange is in reality a subset of managing serious cartel conduct risk. Common sense will dictate most of the immediate responses. If there is not a legitimate business reason and the data is sensitive, then it simply should not be exchanged. If there is a legitimate reason, then sensible policies and guidance can be put in place. In very simple terms, the protocols will seek to control what details are shared, who shares them, and what use the details are put to.
So what should any in-house lawyer really have in mind when thinking about the risks of information exchanges in China? There is probably less sensitivity in China than in other jurisdictions, but it will surely be a matter of time only before Chinese competition authorities get fully interested in the topic. So a common sense approach applies in China, just like everywhere else. And in particular, when business people propose to exchange information with competitors, even for legitimate purposes, such as, for example, a benchmarking study or a due diligence process or the operation of a joint venture. In all these cases, you should ask yourself a few questions. Think about the type of information that is exchanged. Is it very sensitive? Is it information about current or future strategy? Think about the purpose of sharing this information with competitors. Is it really necessary? And then think about any remedial measures that you can put in place to minimize the risk. Have you put in place sufficient measures to ensure that the information that is received is appropriate? And have you put measures in place to ensure that that information will remain in the hands only of those that need to know?
We hope this video summary has been helpful in raising your awareness of some of the current issues in information exchange and price signaling. If you would like to discuss any of the issues raised on this, please get in touch with me or your usual Allen & Overy contact. Thank you very much for watching.